Get more on our top story now. The Constitutional Court finding that President Cyril Ramaphosa did not deliberately mislead Parliament about donations to his CR17 campaign. It also found the Public Protector had no scope to investigate the funding of the campaign. For more reaction, let's speak to legal journalist Karyn Maughan. Karyn, thank you very much for your time. Now, obviously, this is a huge blow to the Public Protector and her office, being found to have been overreaching, being found again to have not actually applied the law properly. And now this might actually be something that makes more people be doubtful of that office.
Well, I think the issue for the Public Protector is that she's currently facing an impeachment investigation into her fitness to hold office after the Reserve Bank judgment and the Estina dairy project judgment given against her, amongst other things. And the president, in that case, where she is now challenging the rules of the impeachment inquiry against her, saying that until this judgment was delivered by the Constitutional Court, he would not, personally make a decision with regard to a possible suspension from office. Now that this pathway has been cleared, the potential suspension of the Public Protector pending that inquiry may in fact be something that could be put into play. Of course, the Public Protector is challenging the constitutionality of that process, which she maintains is profoundly unfair. Damaging for her in this report is, in this judgment, of course, the confirmation of the High Court's findings that she did not appear to understand the Executive Ethics Code, finding that she had inserted the word inadvertent to the code, which dealt with, under which she found that the president had misled Parliament about a 500,000 rand donation that his campaign had received from the late Gavin Watson, finding that she had put the word inadvertent into an act that demanded deliberate misleading of Parliament, finding that she did not have the right to investigate his CR17 funding, that she went outside her jurisdiction, and that she'd also made legally and factually unfounded findings of money laundering against him in relation to his CR17 campaign. But what will no doubt dominate a lot of discussion about this, of course, is that the outgoing Chief Justice, Mogoeng, delivering a dissenting judgment in which he effectively finds in the Public Protector's favor and finds indeed that there was a duty on President Ramaphosa to disclose that funding, and also that Ramaphosa, in relation to leaked emails, which the court in the majority have questioned as evidentially valuable, finding that the president in fact misled the Public Protector in his responses to her. So there's going to be a political dimension and no doubt a fallout, both in regard to the majority ruling, but also in regard to the minority one.
So it's not such a victory for the president, Karyn, because he still needs to go back to the High Court in terms of that amabhungane part of this case.
Well, it's important to remember that the political party funding bill does make provision for the disclosure of private funding, or at least that's what the president's lawyers have argued. It is an important issue. Amabhungane is absolutely correct that the disclosure of private funding to candidates within internal party elections is immensely important. And just as the courts have recognized that political parties need to disclose their funders, so it should be with people contesting in the space of these kind of internal political party contestations. So I think it is an incredibly important development in terms of the media, us being able to track and analyze who is, for instance, supporting specific candidates within internal elections. And of course, the High Court will need to determine ultimately whether the amabhungane was correct in asserting that those kind of provisions needed to be in place within the Ethics Code.
And of course, this is also another big case after that Marikana case that actually puts a little stain on the president and who he is.
Well, I mean, the fact of the matter is that the majority of the court has, absolutely vindicated him in terms of CR17, which remained up until this point one of his biggest political vulnerabilities. It's also important to remember that at this current stage, the EFF is currently seeking to unseal the CR17 records in the High Court in Pretoria. They have argued that case. Judge Sadiwala yet to rule on it. But, you know, one has to wonder whether what the impact of the Constitutional Court's decision will be on that unsealing of the records, you know, given that the court has found that there was no duty on the president to disclose his funders. Of course, the EFF saying that that information about who Ramaphosa's funders were forms part of the court record. Of course, he denies this, and should be disclosed to the public in the interest of transparency. No doubt they will see their stance as being vindicated by Maughan, who maintains that such transparency demands the disclosure of the identities of the CR17 donors.
All right, thank you very much. Legal journalist Karyn Maughan, thank you for your time.